Mr McCormick, could I move on to answers that you gave from estimates last year about the costs associated with an AAT case relating to colour vision deficient pilots? And you indicated that as of the 1st of December 2013, the costs were $43,500. Can you tell me, in terms of forecast costs, how many expert witnesses does CASA plan to call for that inquiry or that tribunal?
Are you talking about the upcoming O'Brien tribunal in July? I'll ask my manager legal branch if I could give you that figure. Thanks, Senator.
You guys are in Gunner. Why don't you just pick up the phone and ring them? Just trying to help you out.
Senator Joe Rule, Manager, Legal Branch. There will obviously be a number of specialist witnesses called to give evidence.
10, 15?
I'm not across the precise number.
Would I be wrong if I said 12?
Look, I couldn't say that number's wrong or out of the ballpark, but I can't give a confirmed number at this stage. The exchange of evidence between the parties has only just finished at the end of last week, I believe, so there will be some toing and froing as to which evidence is required, which witnesses are required, but I can certainly take that on notice and provide a more settled estimate of that for you if that would assist.
You must also have, and that would be good, but you must also have metrics from previous inquiries, knowing the cost, basically what expert witnesses charge for their appearance, travel and accommodation costs, the whole cost of conducting the inquiry in terms of transcript fees, etc. Have you made a provision in your budgeting for how much you anticipate this AET case will cost?
Look, obviously we do forward estimates of how much we think a case is likely to cost. Generally we do it across quarterly budget considerations, so total cost can get washed out as you conduct these cases.
I'm happy to add the figures up, Mr Rule, if you could give me the figures across those quarterly milestones. We
can certainly take that on notice and provide those figures.
Okay, but would it be a reasonable expectation that it would be at least another $43,500 on top of that, which you've already spent, if not significantly more?
It wouldn't be out of the realms of possibility to accumulate another $40,000 in costs, no.
Very understated remark, Mr Rule, but thank you. Could I ask Mr McCormick or Mr Rule, one or the other, in terms of whether or not you move ahead with this, my understanding is that you have an obligation, like any Commonwealth Department, to be a model litigant. And as I look at this, there's about 8 criteria to be a model litigant, and I see CASA not performing particularly well in about 5 of them. Can I ask, what's been the response to Mr O'Brien's request to reach a settlement before the hearing?
I'll defer to Mr Rule if he has any.
Well, there was a mediation conducted last year, in the early part of last year, which was ultimately unsuccessful, and I wasn't aware of any other proposal.
Well, a letter from his lawyers written on in I think February this year.
Yes, I wasn't aware of the specific details of that proposal, but
so you're planning to spend probably over $100,000, and you're not aware of an opportunity to actually reach a settlement before the AET hearing.
Well, I mean, I think at different points along the way, Mr O'Brien has suggested that he would be prepared to resolve the matter, but always on the basis that he have access to the privileges of his airline transport pilot licence. And that, of course, has been the sticking point, or the major sticking point from CASA's perspective, and the reason why those negotiations haven't been successful.
Yes, Senator, I think we've only got the legal cost as a total legal cost, but if you wish to give us on notice the specific areas you think we're not being a model litigant, and we will look at exactly what we've said in the past. And as Mr Rule has said, my understanding is that up till now there has not been any indication that Mr O'Brien wishes to retreat from the position of holding an ATPL.
Sure. I guess I'm interested in two counts. One is natural justice, and we'll come to that in a minute, but the second is value for money for the taxpayer in going down this path. You said in the last estimates that you didn't believe CASA needed to be bound by the Denison case, and that you looked at individual circumstances as opposed to looking at a generic ruling that would apply to everybody. And you also mentioned that you'd be happy to look at the concept of a practical test to satisfy the third level of testing for CVD, which is required or allowed for under CASAR 67 156 subpara C. Where have you got to in that regard, Mr McCormick, in terms of a practical test?
I'll ask my Principal Medical Officer to come forward in a minute and to maybe give you some more background on where we are. What 67 does say is that an applicant for a Class 1 or a Class 2 has to go through 3 stages of testing. The first stage being the Ishihara. If a person passes that, they get an unrestricted medical certificate. If they fail that, they have to do the Farnsworth-Lantern test. If they fail that, there is a third level of testing available, and I think 67 says that's at CASA's discretion what that test is. And this is where last time we discussed using the CAD test in the UK, CAA, as that third level, or some other test as it may be applicable. Before I ask Associate Professor Navati to add a bit more about this, if he wishes to, it's interesting to note that the UK CAA, since we spoke, has adopted the CAD test as their only test. If you fail that CAD test, you do not get a Class 1 certificate at all, let alone with restrictions.
Mere mortals. What's that test?
It's
they run
a
you up a flight
colour.
of stairs, or
It's a vision.
see if you can drink 2 minutes in a row. Or
I think they're all worthwhile tests, but this particular test is associated with what degree of colour vision deficiency you have and the nature of it. Therefore, the medical staff are able to make a better assessment of the effect, and that's where the individual assessment of the case comes in. But 67 does say that you must go through those 3 steps in that order.
I understand. Before we go to Dr. Navathe, you did also say in that period that you didn't believe there was any intention to mandate the CAD test, and that wasn't the direction CASA was going. But I have subsequently seen a couple of examples where CASA refused to renew the medical of people who've previously had multiple renewals of their medical unless they sat the CAD test. Does that not contradict your comment that that's not CASA's intended direction?
I'll go back and check what I actually said it at the time, but my recollection of the conversation was we're talking about using the CAD test as the principal test, rather than the Ishihara or something like that. But as I said, I'll check that on notice. Our view still is that anybody who is entering the industry now and applies for a Class 1 medical certificate, or a Class 2 for that matter, follows 67150 as you've outlined it in those 3 steps as it says they should be done. So the difficulty with mandating the CAD test at the moment, apart from anything else, is the fact that it's only available in 2 places in Australia, and that's Adelaide and Sydney, and I believe it's quite expensive, so we don't necessarily want to go...
$440.
Sorry?
$440.
Yeah, so we don't want to go to the point of pushing people into that test when there are other things available in that third level of testing.
Now, one of the other comments that you made during that estimate were talking about the alternative tests that CASA makes available in the case of audio testing, which can include flight test, where people actually go up and fly and demonstrate their ability, and you indicated that you would look into that kind of a test. Have you made any steps in that regard?
We have not. Well, there is, and again, I'll allow Professor Navate to answer this more fully. We have looked at practical tests, but of course the practical test is supported by the clinical and empirical evidence that we get from the medical testing. It's not a supplant of the medical testing as such, and I think that methodology of saying this is what the medicine shows, is what the data shows us on the ground, is the first step. So the practical test cannot always override the indications from the clinical pathology, if you will. But
Well, again, just before we go